सब्सक्राइब कीजिए ध्येय आईएएस चैनल को और बेल आइकन को दबाइए लेटेस्ट वीडियोस सबसे पहले देखने के लिए।
The Union Cabinet has recently announced some major amendments to the Juvenile Justice, Care and Protection of Children Act 2015. This amendment has been recommended keeping the thought to bring clarity along with entrusting more responsibilities on bureaucrats when it comes to implementing provisions of the law. The amendment has been brought on the basis of a report filed by the NCPCR in 2018-2019. Within this, over 7,000 children care institutions were surveyed, and it was found that 1.5% do not conform to the rules and regulations of the Juvenile Justice Act, and 29% of them had major shortcomings in their management. According to the NCPCR report, not a single child care institution in the country was 100% compliant to the provisions of the Juvenile Justice Act. In this edition of our DNS, we will be talking about Juvenile Justice Act in detail and also talk about the amendments announced recently. Let us first begin by understanding what is Juvenile Justice Act. The Juvenile Justice Care and Protection of Children Act was passed and launched in the year 2015. It replaced the Juvenile Delinquency Law and the Juvenile Justice Care and Protection of Children Act 2000. Now let us move further by knowing the provisions of the new Act. The major provisions of the new Act was that it allowed the trials of juveniles in conflict with the law in the age group of 16 to 18 years as adults, in cases where the crimes were to be determined. The nature of the crime and the juvenile and whether the juvenile will be tried as a minor or a child was to be determined by a juvenile justice board. The provision received a stimulus after the 2012 Delhi gang rape, in which one of the accused was just 18 years and was therefore tried as a juvenile. The second provision was in regards to adoption, bringing a more universally acceptable adoption law. This was in replacement of the Hindu Adoptions and Maintenance Act 1956 and the Guardians of the Ward Act 1890 for Muslims, but the Act did not replace these laws. The Act also helped in streamlining adoption procedures for orphans, abandoned and surrendered children. The Central Adoption Resource Authority has been given the status of statutory body so that it can perform more effectively. Now let us know about the amendments passed by the Union Cabinet. As per the Juvenile Justice Act 2015, juveniles who are charged with heinous crimes, along with the ones in the age group of 16 to 18 years, will be considered as adults and will be processed through the adult justice system. Both heinous and serious crimes have also been clarified for the very first time, removing any ambiguity. This provision will help in keeping children away and protected from the adult justice system. The juveniles in the age group of 16 to 18 years could be tried as adults for a crime in cases of possessions and sale of an illegal substance such as drugs or alcohol, which will now fall under serious crime. With the approval of new amendments, there has also been an expansion in the purview of district and additional district magistrates. They will be monitoring the function of multiple agencies under the Juvenile Justice Act in each district. It will include the child welfare committees, the juvenile justice boards, the district child protection units, and the special juvenile protection units. Also, the new amendment ensures that no new children's home can be opened without the sanction of the DM, and to accelerate the process of adoption and ensure the swift rehabilitation of children into homes and foster homes, the amendment further authorizes the DMs as in charge of sanctioning adoptions, removing the lengthy court processes. Now let us know about the conclusions of this new amendment. Although the amendment has been welcomed by many in its attempt to provide children in need of care, but it has also expanded the responsibilities of the DMs.